7 counts. Count 1 being trafficking cocaine, a felony with the 4th degree, in violation of ORC 292503A1 with the forfeiture specification. Count 2, trafficking cocaine, a felony with the 3rd degree, in violation of ORC 292503A1 with the forfeiture specification. Count 3, possession of cocaine, a felony with the 5th degree, in violation of ORC 292511 with the forfeiture specification. Count 4, aggravated possession of drugs, a felony with the 5th degree, in violation of ORC 292511 with the forfeiture specification. Count 5, possession of cocaine, in violation in ORC 292511, also a felony with the 5th degree with the forfeiture specification. Count 6, possessing criminal tools, a felony with the 5th degree in violation of ORC 2923.24 with the forfeiture specification. And count 7, receiving proceeds subject to forfeiture, felony with the 5th degree in violation of ORC 2927.21b, also with a forfeiture specification. With regarding the information, Judge, that is 1 count of possession of cocaine, a felony of the 5th degree in violation of ORC 292511 with the forfeiture specification. Judge, regarding both of these cases, the state and defense have reached a global resolution. That resolution being in the change of plea case 000451. It's my understanding that the defendant will plead to 3 counts. Count 1, the trafficking cocaine, felony 4, with the forfeiture specification. Count 2, in the lesser included offense, trafficking cocaine, felony of the 4th degree, with an amended amount. That amended amount of cocaine equal to 5 grams, but less than 10 grams, with a forfeiture specification. And count 3, possession of cocaine, felony of the 5th degree, with the forfeiture specification. And we will dismiss the remaining counts. With regard to the forfeiture specifications of the remaining counts, it's my understanding that the defendant voluntarily forfeit the remaining contraband and instrumentalities attached to the dismissed counts. However, with regards to count 7, the receiving proceeds subject to forfeiture, the cash of $1,094. It is my understanding that the defendant does, and Ms. Carroll might be able to explain this further, but does have evidence to show that that was obtained legitimately, has bank account statements that we don't have yet, but if those are legitimate, would be okay with without forfeiting that cash.
Well, is he pleading to that?
No, that can't be dismissed. But
that specification is being dismissed.
Yes.
Okay. Well, then not going to forfeit the money.
Well, Judge, the remaining counts would still be forfeiting the contraband and instrumentalities of the dismissed count. That's a voluntary agreement. So
that's between the two of you.
Well, that's my understanding, that we came to that agreement with the time. That's all.
Okay. Well, you're saying I see what you're saying. If she provides you documentation, then that part of the voluntary agreement is gone. If she doesn't, then they're agreeing to forfeit it.
Yeah. Yes.
Ms. Carroll, does that all sound accurate?
Yes, Your Honor. That's all my understanding as well.
So did the second case, the information, he was indicted, but he hadn't been arraigned or anything on that?
Correct.
I'm assuming it's probably when he was arrested that they had this on him?
Exactly, yes, Judge.
All right, Mr. Boyce, we're able to hear what the prosecutor had to say regarding what, what he believes your plans are as to both of these cases.
Yes, sir.
He indicated to the court that he believes it's your desire in case 22 CR 451 to withdraw your previous entered plea of not guilty and plead guilty to 3 charges out of that case, and I'll go over those charges with you. The other counts will get dismissed. Case 22 CR 558, you waive your right to have the case presented to a grand jury and plead guilty to the 1 count of possession of cocaine. Going back to that first case, you'd be pleading guilty to the forfeiture specifications that are part of the 3 charges pleading guilty to. The other forfeiture specifications, you are voluntarily agreeing to forfeit the contraband instrumentalities and/or possibly proceeds that are set forth in the specifications. As for the proceeds, though, $1,000, I think it was a little over $1,000. If you're able to provide documentation to the state in demonstrating that it's obtained in some legitimate manner, the state's going to agree not to require forfeiture of that. But if not, then that would be forfeited. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and more importantly, what you want to do here at this time?
Yes, sir. That's my understanding.
Well, before I can accept your guilty plea to charges in either of these cases, I need to make sure you understand everything that's going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all these issues, I am going to ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that's going on, all right?
Yes, sir.
All right. Well, let's get started here then. How old are you, sir?
56.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came to court here today, have you had any drugs or alcohol of any
No.
kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
I have nothing prescribed.
Now, in the first case, the 22 CR 451, I know you received a copy of the indictment in this case. You should have gotten that. It appears you would have gotten that sometime at the beginning of June. Do you remember getting that?
Yes, sir.
You had a chance to look that over?
Yes.
Now, in that indictment, you are charged with 7 separate counts. You're pleading guilty to 3 charges out of this indictment, so I'm going to go over those with you and what you're actually pleading guilty to. In count 1, what's alleged here and what you're admitting to is on or about September 2nd, 2021 in Manor Lake County, Ohio, that you did knowingly sell or offer to sell cocaine or some compound mixture, preparation, or substance containing cocaine. The amount of cocaine involved equal or exceeded 5 grams, but it was less than 10 grams. Specifically, it was 8.31 grams, which makes the offense trafficking cocaine a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, sir.
Any questions about that?
No.
Now, this count also carries a forfeiture specification with it that alleges during the commission of the offense you possessed or had interest in property that was considered to be contraband. Contraband is property that's illegal to possess because of the nature of the property itself. In this case, the alleged contraband is the cocaine that was involved. And the whole point of this is that you forfeit any right you have to that. Do you understand that?
Correct.
Okay. Now, in count 2, what's alleged here, this isn't what you're pleading guilty to, but what's alleged is on or about October 19th, 2021 in Manor Lake County, Ohio, that you did knowingly sell or offer to sell cocaine or a compound mixture, preparation, or substance containing cocaine. The amount involved was over 10 grams, but less than 20 grams. It was 11.09 grams. That charge constitutes the offense of trafficking in cocaine because the amount's over 10 grams. It's a felony of the 3rd degree. Do you understand what you're charged with in this count? That's not what you're pleading guilty to, but that's what you're charged with?
Yes.
Any questions about it?
No.
Now, for purposes of the plea today, the state has agreed to amend count 2 to allege that the weight involved was between 5 and 10 grams. So we're agreeing to lower the weight. And the significance of that is that it reduces it from a felony of the 3rd degree, which is more serious, to a felony of the 4th degree, which is less serious. You understand the difference there then?
Yes, I do.
So you understand what you're actually pleading guilty to?
Yes.
All right. Now, this count also carries with it that same forfeiture specification regarding the contraband being cocaine involved. You understand that?
Yes.
Now, the 3rd count you're pleading guilty to is count 3. It's alleged on or about October 22nd, 2021 in Manor Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved did not equal or exceed 5 grams. It was 0.24 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to here?
Yes.
Any questions about it?
No.
And again, this count also carries with it that same forfeiture specification. You understand that?
Yes.
All right, now there are 4 other counts in this indictment. All of those are getting dismissed pursuant to the agreement between your attorney and the prosecutor. Do you understand that?
Yes, sir.
Any questions about any of those four?
No.
Now, in the other case, 22 CR 558, there's one count. Did you receive this information?
Yes, I did.
Get a chance to look it over?
Yes.
Now, in that information, what's alleged here is on or about June 2nd, 2022 in Wickliffe Lake County, Ohio, that you didn't knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved was less than 5 grams. It was 4.75 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about it?
No.
Now, this charge also carries with it that same forfeiture specification regarding cocaine. Do you understand that?
Yes.
Any questions about that?
No.
So do you understand the nature of the charges that you're pleading guilty to in both of these cases?
Yes.
Any questions for me?
No.
Well, then before I can accept your guilty plea in either of these cases, I need to make sure you understand all of the rights you're giving up in each case. And I'm going to start with the newer case first, the one count of possession of cocaine. In that case, you have been charged by way of what's called an information. And an information is charges brought by the prosecutor's office without this case having previously been reviewed by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether a probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently consider the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. In fact, that's what happened in the other case you're pleading guilty to. That went to a grand jury. The grand jury considered all the evidence and found probable cause for the 7 charges that it returned. So you have the right to have the same grand jury consider the evidence in this case, but you can also waive that if you want and go forward on a charge brought by the prosecutor and the information. And your attorney has indicated she believes that's what you want to do in this particular case. Is that correct?
I want to waive it.
Well, then before I can accept a guilty plea, I need to make sure you understand, well, strike that. First of all, what I have in regards to that waiver is a document of a waiver. It's called a waiver of indictment. I need to make sure you understand what's in this document before I can accept your plea. And my understanding is you had a chance to look this over with your attorney before I came out here. Is that correct?
Yes, sir.
Ms. Carroll, is that accurate? Did you read this to your client and go over with him?
Yes, Your Honor.
Did he understand it?
Yes, Your Honor.
Is that correct, Mr. Boyce?
Yes, sir.
Any questions for me about what it says?
No.
Now, it appears you signed this document. Did you in fact sign it?
Yes.
And Mr. Carroll and Mr. Fife, you both witnessed that?
Yes, Your Honor.
Yes, Your Honor.
All right, then I will make this document part of the record. At this point, Mr. Boyce, I'm going to go over all the other rights you have and the rights you're giving up by pleading guilty. And these rights I'm going to go over with you at this point, they apply to both cases. I'm not going to go over them twice for each case. All these rights apply to both cases. If there's anything particularly applies to one case and not the other, I'll make sure I point that out to you. But otherwise, everything I'm telling you goes to both cases, all right?
Yes.
All right, and first of all, you have a right in each of these cases, first off, to have a trial. The trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. That means all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you are giving up your right to have a trial in either of these cases?
Yes, sir.
Now, if you had a trial in either of these cases, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Now, by him having the burden of proof, what that actually means is that it's his job, or it's his responsibility to prove you guilty at a trial before you could ever be found guilty. You are presumed innocent of all the charges in both of these cases, and that presumption of innocence sticks with you and stays with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, as far as the burden of proof goes, since these are both criminal cases, that burden of proof is what we refer to as proof beyond a reasonable doubt, which is the highest burden of proof there is in our justice system. What it actually means, it's the amount of evidence and the quality of the evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these individual offenses beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, to prove you guilty at a trial, if we did have a trial, the prosecutor would be bringing witnesses to come in the court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your attorney can ask those same person's questions for you on your behalf. That's called cross-examination. She could ask them anything she wanted to, within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come in court and testify for you if you wanted to and answer your lawyer's questions. But you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. When we call that order a subpoena, what a subpoena would actually do is it would force or make someone come in the court to testify for you and answer your lawyer's questions if they were not willing to do so voluntarily. Do you understand that?
Yes, sir.
And do you realize you're giving up that right?
Yes.
Now, you would also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. You understand that?
Yes, sir.
So what that actually means then is that nobody else can force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of the guilty plea is that you're going to be found guilty by the court, and then you'll subsequently, there's one other thing I want to make sure I advise you of. By pleading guilty here today, then you're waiving any right you have to appeal a guilty finding that I make, as well as any other issues or challenges you could have raised up to this point. Do you understand that?
Yes, sir.
All right. So do you have any questions then regarding any of the rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading
No,
guilty?
sir.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
And do you understand your guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that is that you'll be found guilty by the court, and then you'll subsequently be sentenced by the court. Do you understand that?
Yes, sir.
Now, in regards to the first case, the 7-count indictment where you're pleading guilty to the 3 charges, count 1 and the lesser offense of count 2 are both felonies of the 4th degree. Each of these carry with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, count 3, the possession of cocaine charge is a felony of the 5th degree. This carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, since there are 3 separate charges here, if I imposed a prison sentence, I would impose a prison sentence on each count. And then as a judge, I have the discretion to run those terms either concurrent or consecutive to each other. Concurrent means you serve them together at the same time. Consecutive means one after the other. Do you understand the difference there?
Yes, I do.
So in this case, if I was to impose the maximum prison sentence on each of the 3 counts you're pleading guilty to, excuse me, and run them all consecutive, you're looking at a maximum possible prison sentence, in this case, of 4 years in prison. You understand that?
Yes.
Now, in the other case, the possession of cocaine charge is a felony of the 5th degree. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, in regards to both of these cases, when we come back for sentencing, we're going to come back on the same day for both cases for sentencing. And if I impose a prison term in each count, in each case, not only can I run those counts consecutive like I explained in the first case, but I can run a prison term in each case concurrent or consecutive to each other. Do you understand that?
Yes.
So with both of these cases together, there's a maximum possible prison sentence of 5 years in prison. Do you understand that?
Correct.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Do you have any other charges pending against you anywhere else?
No.
If a prison sentence is imposed in either of these cases, upon your release from prison, you could be placed on what is called post-release control. We sometimes call that parole. It's a period of supervision you would be on after you serve the prison sentence, and it could be for up to 2 years in these cases. Do you understand that?
Yeah.
And if you are on post-release control and never violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit.
Yes.
Well, wait till I'm finishing. I'm just making...
Oh, I'm sorry.
That's all right.
I'm feeling sick.
Yeah, I was just going to
Can I
say...
go to the restroom? I think I might be puking.
Here, turn. I'll make it.
Well, he's all right, Stan. Oh. Did he leave? He leave? All of a sudden, I saw him... maximum possible fine of $2,500 that can be imposed. You understand that?
Yes, sir.
So with both cases together, it's possibly $15,000. You understand that?
Yes, sir.
You all right? You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
You can also have your driver's license suspended. I could suspend your driver's license for up to 5 years. Do you understand that?
Yes, sir.
And then lastly, regarding those forfeiture specifications, any right, title, or interest you have in the property that's set forth in those specifications for the charges you're pleading guilty to, the court would order that they be forfeited to the state of Ohio. Do you understand that?
Yes, sir.
And there's also been an agreement reached for the other property, including the proceeds, unless you present documentation showing otherwise, that would be forfeited. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison's not mandatory. You are eligible for probation, or what's called community control sanctions. Do you understand that?
Yes, sir.
Do you understand just because you're eligible doesn't mean you'll be automatically put on probation? It means I'll consider that.
Yes.
I'll look at all the information, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years, and as a judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve time in the Lake County Jail as a condition of probation. Do you understand that?
Yes, sir.
So even if you put on probation, that doesn't mean there's automatically no jail time. It means you're not going to prison, but there could be, and it's not automatic or mandatory, but there could be local jail time in the Lake County Jail as a condition that you have to serve as a condition of probation. You understand that?
Yes, sir.
Questions about that? The maximum that could be, if I put you on probation, but order jail time as a condition of probation, the maximum that could be is 6 months. Do you understand that?
Yes, sir.
Okay. Now, if you are put on probation at any point and you violate the conditions of your probation, we will have a hearing to see if you're a probation violator. If it's determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it could be for the period of time I explained earlier for each of the cases, and combined all together for both cases, it could be 5 years in prison. You understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the attorney said at sentencing regarding what they think the sentence should be, it is just what it says. It's a recommendation. I don't have to follow that if I don't think it's the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, I don't.
Understand all the possible consequences?
Yes, I do.
You still want to plead guilty?
I want to plead guilty.
Have you had enough time to talk about both of these cases with your lawyer? Have her review the reports with you, discuss the issues, and answer your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has she or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then, do you have any questions for me at this point regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to?
No.
Do you need any more time to talk with your lawyer before we go forward with the actual?
No.
All right, then what we're going to do at this time is the prosecutor here is going to explain for me what he believes the evidence would show in each of these cases. If we did have a trial, I want you to listen to what he says, because I'll have some follow-up questions for you, all right?
Yes, sir.
All right. Mr. Fife, let's start with 22 CR 451, the multi-count indictment.
Thank you. Had that case proceeded to trial, the facts would show that 2 controlled buys were conducted by the Lake County Narcotics Agency. Both of those taking place at the Manor Wood Spring Suites in Manor Lake County, Ohio. The defendant was residing at the time. One controlled buy took place on September 2nd. That controlled buy was for 8.31 grams of cocaine, scheduled to substance. The second one occurred on October 19th. That one was for an amount greater than 5 grams, but less than 10 grams of cocaine. After those controlled buys, there was a search of the defendant's room where he was staying. They located 0.24 grams of cocaine. That search also resulted in other findings, such as digital scale, container of anisotyl powder, baking soda, plastic straws, and glass smoking pipes, and then the mentioned cash of $1,094.
Mr. Boyce, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial in this case?
Yes, sir.
What, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
Yes, sir.
Very well, then regarding count 1 and count 2, each charging you, well, count 1 and the lesser included offense of count 2, each charging you with trafficking cocaine, each felonies of the 4th degree. With the forfeiture specifications, what is your plea to that?
Guilty.
Regarding count 3, charging you with possession of cocaine, a felony of the 5th degree. Matt, did I say possession of cocaine for the first one? Let me start over. Regarding count 1 and lesser offense of count 2, each charging with trafficking cocaine, each felonies of the 4th degree with the forfeiture specification. What is your plea to that?
Guilty.
Regarding count 3, charging with possession of cocaine, a felony of the 5th degree with the forfeiture specification. What is your plea to that?
Guilty.
All right. Mr. Fife, proceed to the next case, please.
Thank you, Judge. Had that case proceeded to trial, the facts would show that on June 2nd of this year in the city of Waiver, Ohio, the defendant from the Waiver Police conducted a traffic stop on the defendant's vehicle. A search followed that stop. During that search, police located 4.75 grams of cocaine, confirmed by the liquor department.
Mr. Boyce, were you able to just hear what the prosecutor said in regards to what he believes the evidence would establish in case
Yes, sir.
22 CR 558?
Yes, sir.
And what, if anything, did it say of those facts? Are those true as well?
They're true.
Very well. Regarding count 1 in case 22 CR 558, charging with possession of cocaine, a felony of the 5th degree with the forfeiture specification. What is your plea to that?
Guilty.
All right, I have in my possession at this time 2 documents. These documents set forth everything I've just explained to you regarding the rights you're giving up and the penalties you face. Before I can accept your guilty plea, I need to make sure you understand what's in these documents, and you sign them here in open court. Mr. Shadow, if you can take this over to... So we made a change in regards to... There was just a couple lines that were missing out of the change of plea form in 22 CR 451, which would be the first 3 lines on the 4th page, if you want to go over those with them, but it's nothing that's different than I've told you here. Before I can accept your plea, you need to sign that document here in open court. So it's the 4th page, top 3 lines. Yeah, we're talking about the maximum fine, the total together. All right, I'm being handed now in regards to case 22 CR 451, a document, 5-page document, the written plea of guilty and judgment entry. So you reviewed this document with your lawyer?
Yes, I did, sir.
You understand what it says?
Yes.
Any questions for me about it?
No.
I also have the similar document, written plea of guilty and judgment entry for 22 CR 558, which is basically identical, except it just has a specific charge for that particular count versus the 3 charges for the other case. Otherwise, they're the same. You had a chance to look that document over earlier with your lawyer as well?
Yes, I did.
And is that correct, Ms. Carroll? You went over both of these documents with your with your client?
Yes, Your Honor.
Did he indicate an understanding of them to you?
He did.
And did he sign both of them?
He did.
Did you sign both of them?
Yes, I did.
Can you witness that, Mr. Fife?
Yes, Your Honor.
Any questions for me at all, Mr. Boyce, regarding what these documents say?
No.
You understand them all?
Yes.
Very well then, at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. In case 22 CR 451, find the defendant guilty of count 1 and the lesser included offense of count 2, each being trafficking in cocaine. Each felony is of the 4th degree in violation of 2925.03A1 with the forfeiture specification. The defendant will also be found guilty of count 3, possession of cocaine, a felony of the 5th degree in violation of 2925.11 with the forfeiture specification. The remaining counts 4, 5, 6, and 7 will be dismissed at sentencing. In 22 CR 558, the court will accept the defendant's plea and find the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree in violation of 2925.11 with the accompanying forfeiture specification. Again, the sentencing will be deferred in both of these cases. I'm going to refer the matter to the probation department for a pre-sentence report as well as the drug and alcohol evaluation. I'll continue bond in each case. You have the bond paperwork for the
Yes, sir.
case. In 451, bond will be continued at own recognizance. In case 22 CR 558, bond will be continued at $10,000 cash surety or 10%. So what's going to happen at this point, Mr. Boyce, as far as your bond goes, I've continued your bond, so there's nothing more you need to do about that, except you need to continue complying with the conditions of your bond. One of those conditions is that you don't use any drugs. He needs to fill out this conditions form. But one of the conditions of your bond has been and will continue to be that you don't use any drugs while you're on bond. You have to submit urine screens. If they should come back positive, your bond would get revoked and a warrant would be issued for your arrest. You understand that?
Yes, sir.
Now, these reports that I've ordered, so I can learn more about you prior to sentencing, and the way the probation department gets the information they need to generate these reports and prepare the reports, they're going to conduct some interviews with you. It's important that when you meet with them and speak with them that you're open and honest, because they're going to check and verify everything you're telling them. And if they determine you're misleading them in any way, they're going to let me know that, and I would consider that as sentencing. You understand that?
Yes, sir.
Lastly, in order for the court to consider probation as an option, these reports have to be completed. Without a pre-sentence report, I'm not allowed to consider probation. In order for that report to be completed, the interview with you has to take place. So it's important that you show up and cooperate with probation when you're supposed to be there, so they can conduct the interview and they can prepare the report. Without the interview, there's no report. Without a report, I can't consider probation. You understand that?
Okay, yes, sir.
So you're going to leave here now and go over to the probation department. You feel well enough? You have a mask with you?
No.
You should get a mask. I want you to wear a mask when you go there. We have some?
Yes, sir.
Give them one. You need to go over there, fill out some initial paperwork. Where do you live?
In Wycliffe.
Fill out some initial paperwork, and you're going to get a date to come back for your sentence. So make sure you go over there.